Hello everyone, welcome to the second part of the Indian Polity Swift revision series. And till last session, we were discussing about the fundamental rights, and from now onwards, we are going to start with the DPSP, that is Directive Principles of State Policy. So without wasting much time, we are moving into the program. Okay. The Directive Principles of State Policy, that is DPSP. So this is the fourth part of the Indian Constitution, Very important to understand that. And Article 36 to 51 of the Constitution mainly discuss about the directive principles of state policy. Okay, very important concept. When we are talking about the fundamental rights, we already mentioned that it is justiciable in nature. But when it comes to directive principles, it is not justiciable, non-justiciable in nature. Let us see what is all the importance of this particular part. Okay, so Article 36 to 51 of the Indian Constitution talk about the DPSP, and it is coming in the part 4 of the Indian Constitution, and they are borrowed from the Constitution of Ireland. We can say that Irish Constitution, and the Irish Constitution has copied it from the Spanish Constitution. Okay, please understand this. It is non-justiciable in nature. What do you mean by non-justiciable in nature? Because if somebody is actually violating the DPSP principles, then you cannot go and approach the court saying that, okay, somebody has violated this. No. When somebody is violating the fundamental rights, we can definitely approach the court. That is justiciable in nature. But here, this is non-justiciable in nature. DPSP are ideals. Okay, basically certain ideas, certain values, which are meant to be kept in mind by the state when it formulates policies and enact laws. So when you're actually going through this, you will understand that. I hope you know about it already. So basically, these are certain ideals which the state can keep in mind when they are actually enacting the laws. And the objective of this is to establish economic and social democracy in the country. And they are instrument of instructions for the state while formulating the laws. And Dr. B.R. Ambedkar, the architect of the Indian Constitution, mentioned that it has the novel features of the Indian Constitution. And Granville Austin, one international jurist and constitutional expert, mentioned that DPSP and fundamental rights are the conscience of the Constitution. Okay, so very, very important to understand about DPSP. And when we are talking about DPSP, it is mainly classified into 3 categories. Okay, we will see that. So, they are constitutional instructions or recommendations to the state in executive, administrative, and legislative matters. And state has the same meaning as in the fundamental rights. So, like when we were discussing about Article 12 of the Constitution, what was the concept in that? We are actually trying to define state. What do you mean by state? What are the authorities coming under the ambit of this state, the definition of state? That was the one we were discussing. Same like that, Article 36 of the Indian Constitution is also mentioning about the state, the definition of the state. And they are like instrument of instructions which are enumerated by the Government of India Act 1935 to the Governor General and other governors by the British government. Basically, instrument of instruction. So certain instructions given to the state. And why they are actually giving it to the state? Whenever the state is planning to make a law and for the welfare of the people, definitely they can consider these instructions. Okay. They aim at realizing high ideals of justice, liberty, equality, and fraternity. And they follow the concept of welfare state. The welfare of the people is one of the important motto of this particular part. Okay, they are not legally enforceable by the courts for their violation, but you can see that the concepts or the ideals of the DPSP were taken by the parliament to make many laws. And when you're actually violating the concepts of those laws, then definitely you are punishable under the law. Okay, then while checking the constitutional validity of the law, if it seeks to give effect to directive principle, it may consider such a law to be reasonable. Okay, so that's the importance of the directive principles of state policy. These are certain directions given to the state. Okay, novel features of the Constitution. Now, what is the classification? Broadly, you can see that the DPSP can be classified into 3. Okay, this is for our own convenience because the Constitution has not classified it in these terms. Okay, we are actually classifying it for our own convenience. So when we are looking at each of the principles, you can relate it with certain things. That is what we are actually mentioning it here. And the first category is socialistic principles. The second category is Gandhian principles, and then liberal intellectual principles. So what do you mean by socialistic principles? They aim to provide social and economic justice and set path towards the welfare of the state. So social and economic justice and path towards welfare of the state. So when it comes to Gandhian principles and mainly the ideals of Mahatma Gandhi, the philosophy of the Mahatma Gandhi was taken into consideration while forming this to represent the program of reconstruction enunciated by Gandhi during the freedom movement. Now, liberal intellectual principles, mainly this category represents the ideology of liberalism. Okay, the ideology of liberalism. Now, let's see each and every aspect. The socialistic principles, so mainly focusing on the welfare of the people. So what are all those things? And now when we are seeing this, it is not coming in order. Okay, this is mainly coming based on the category part. Okay, Article 38 of the Constitution is actually one of the socialistic principles. What is that? Promote the welfare of the people by securing social order through justice, social, economic, and political, and to minimize inequalities in income, status, facilities, and opportunities. Basically, they are trying to establish justice in the society, economic and political justice, social justice. All those things they are trying to establish through Article 38. Now, Article 39 secures citizens to adequate means of livelihood for all citizens, equitable distribution of material resources of the community for the common good, then the prevention of concentration of wealth and means of production, then equal pay for equal work for men and women, then preservation of the health and strength of workers and children against forcible abuse, then opportunities for the healthy development of children. So when you're looking at this itself, you can see that it is for the welfare of the people. They look at the health aspects of the people, they look at the economic aspects of the people, they look at the livelihood of the people, because everything is included. Social aspects, economic aspects, political aspects, everything is included in the socialistic principle. So that is about Article 39 of the Indian Constitution. Now, Article 39A of the Indian Constitution talks about promoting equal justice and free legal aid to the poor. Okay, equal justice and free legal aid to the poor. Suppose if somebody is not able to appoint an advocate for their own case, then free legal aid will be provided by the state. So that is what is mentioned in this one, Article 39A of the Indian Constitution. So, Article 38, Article 39, Article 39A. Now, Article 41. Okay, in cases of unemployment, old age, sickness, and disablement. Okay, in these conditions, during these conditions, secure citizens' right to work, right to education, and right to public assistance. So that is also welfare for the people, right? When in case of unemployment or old age or sickness or disablement, it actually secures the citizens to right to work, right to education, and right to public assistance. Article 42 talks about make provision for just and humane conditions of work and maternity relief. Very good, right? Just and humane conditions for work in a work environment, how it should be for the welfare of the people, how it should be for the maternity relief. That is what is mentioned here. And Article 43 talks about secure a living wage, a decent standard of living, social and economic opportunities for all workers. Okay, all the workers, living standards should be improved. They should be having a decent standard of living. Okay, Article 43. Article 43A talks about take steps to secure participation of workers in the management of industries. In the management of the industries also, we need to take into consideration the participation of workers. Then Article 47 talks about raise the level of nutrition and standard of living of people and to improve public health. So nutrition, standard of living of the people, and improvement of the public health. Okay, so when you're looking at these principles itself, you can see that it is mainly focusing on the welfare of the people only. Now, certain Gandhian principles. Article 40 is actually mainly dealing with the Gandhian principle. Organize village panchayats and endow them with the necessary powers and authority to enable them to function as units of self-government. Now, we are enjoying that, right? Like we are having a local self-government. It actually came from the idea of Mahatma Gandhi only. Now, Article 43, promote cottage industries on an individual and cooperation basis in rural areas. Cottage industries need to be promoted, Gandhian idea. Then 43B talks about promote voluntary formation, autonomous functioning, democratic control, and professional management of Cooperative societies. We have seen that it is one of the salient feature of the Indian Constitution itself, and it is also there in a particular part of the Indian Constitution. Cooperative societies, establishment of cooperative societies. That is also one of the Gandhian principle. Now, Article 46 talks about promote education and economic interest of SC, STs and other weaker sections of the society and to protect them from social injustice and exploitation. So, looking at the downtrodden people, looking at the welfare of the backward sections, that is what is mentioned here. So, protection and the safety and also the welfare and development of them. Okay. Then Article 47 talks about prohibit the consumption of intoxicating drugs and drinks which are injurious to health. So banning liquor or banning drugs, that is what is mentioned here, Gandhian idea. Consumption of intoxicating drinks and drugs. Then Article 48 talks about prohibit slaughter of cows, calves and other milch and draught cattle and to improve their breeds. Okay. So prohibition of cow slaughter or prohibit the slaughter of cows, okay, and calves and other milch and draught cattle to improve their breed. So not only looking at the welfare of the people, it also looks at the welfare of the animals also. So these animals, if you look at, you can see that they are more connected to the livelihood of the people. Okay, so that is why Mahatma Gandhi is actually supporting this cause. Now, the liberal and intellectual principles. Article 44 is a basic example for that. Securing citizens a uniform civil code throughout the country. You might have witnessed a lot of discussions related to uniform civil code in the country. So that is a part of the DPSP. From DPSP only, they are actually trying to take it and making it as a law. Then Article 45 provide early childhood care and nutrition for all children until they complete the age of 14 years. Okay, so nutrition and education of these children should be taken care of until they complete the age of 14 years. Then Article 48 talks about organized agriculture and animal husbandry on modern and scientific lines. Okay. Then Article 48A talks about protect and improve the environment and to safeguard forest and wildlife. So now we are looking at the forest also, looking at the environment aspects also, 48A. Then Article 49 talks about protecting monuments, places and objects of artistic and historical interest which are declared to be of national importance. So the museums of national importance, monuments of national importance or places of national importance need to be protected and preserved. Then Article 50, separate the judiciary from executive in the public services of the state. Separate judiciary from executive. Basically, separation of powers. Okay, they need to function as independent units. That is one idea from the liberal intellectual principles. And Article 51, okay, classic example talks about the international aspects. Promote international peace and security and maintain just and honorable relations between nations. International peace and security is also one of the major aims or ideals of the Indian Constitution. Then foster respect for international law and treaty obligations, very important. So international law and treaty should be respected and should be followed. Then encourage settlement of international dispute through peaceful means, that is also or by arbitration. That is also one of the important feature of the liberal intellectual principles of DPSP. Okay, Article 51, very, very important, because in the Article 51 only they are mainly talking about the international aspects. Now, certain new principles or new additions were there in the Constitution, especially in the DPSP area. So, through the 42nd Amendment Act, very important. So, what are they? Article 39 to secure opportunities for healthy development of the children. Then Article 39A to promote equal justice and provide free legal aid to the poor. Article 43A takes steps to secure the participation of workers in the management of industries. Article 48A talks about to protect and improve the environment and to safeguard the forest and wildlife. So all these are certain additions to the Indian Constitution, especially in the DPSP area, Directive Principles of State Policy area. So now you can understand, no, like how important it is. Okay, these are all novel features. These are all noble ideals. So this need to be taken into consideration and make it as a law. And that has happened in the past history. If you look at it, you can see that many of these principles were taken and many of these principles were converted as laws or acts in the country. Then Article 38 was added by the 44th Amendment Act of 1978, and which requires the state to minimize inequalities in income, status, facilities and opportunities. Article 44 Amendment, Article 38. Then the 86th Amendment Act of 2002, you can see that changed the subject matter of Article 45 and made elementary education a fundamental right under Article 21A. So we have already discussed that. Okay, through which amendment it came? 86th Amendment Act 2002. The amended directive requires the state to provide early childhood care and education for all children until they complete the age of 14 years. Okay. Now this you will be able to see it in the fundamental duties also. Okay, it is a duty of the parents. Then a new DPSP under Article 43B was added by the 97th Amendment Act of 2011, mainly relating to cooperative societies. Cooperative societies. It requires the state to promote voluntary formation, autonomous functioning, democratic control, and professional management of cooperative societies. Very important. The Indian Constitution under Article 37 makes it clear that DPSP are fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. So that is the objective. These instructions need to be taken into consideration while making laws for the society. Then criticism. For everything there will be advantages and disadvantages. For criticisms will definitely be there. So one criticism is like it has no legal force. We already mentioned that because it is non-justiciable in nature. It is illogically arranged. So it may not be arranged in a proper manner. In the constitution, it may not be arranged in a proper manner, like the articles wise, if you're looking at. But when you're actually looking at the category that we have created, no, then you can see that it has some kind of connection. It is conservative in nature. It may produce constitutional conflict between state and the center. So these are some of the criticisms regarding the DPSP. Now coming to one of the major areas of the Indian Constitution, that is fundamental duties. So we discussed about fundamental rights, we discussed about directive principles. Now, while you are enjoying fundamental rights, you should be aware that you have certain duties or obligations towards the society. That also should be taken care of. So Article 51A of the Indian Constitution deals with fundamental duties. So that article, when you're actually seeing that itself, you will understand that it was not there in the original Constitution. It was added as an amendment, 51A. Okay. The Swaran Singh Committee was established in the year 1976 and it was intended to make suggestions and proposals respecting the fundamental duties. So that was the duty of Swaran Singh Committee in 1976. The committee recommended that fundamental duties should be included as a distinct division of the Constitution. Very important, a very constituent division of the Constitution. Then the Congress government at center accepted these recommendations and enacted the 42nd Constitutional Amendment Act of 1976. And with that only they have included the fundamental duties. 42nd Amendment, Constitutional Amendment Act of 1976. Added a new part, namely Part 4A to the Constitution. New part. And Article 51A deals with fundamental duties. Now, what are the important aspects of the fundamental duties? Part 4A of the Indian Constitution talks about the fundamental duties, and here you can see that what are the fundamental duties. To abide by the Constitution and respect its ideals and institutions, the national flag and national anthem. Abiding the Constitution, respecting the national flag, national anthem, ideals and institutions. To cherish and follow the noble ideals which inspired our national struggle for freedom. So we need to look at the struggles of our freedom fighters, the philosophies of our freedom fighters, and to cherish and follow the noble ideals of that. Now, to uphold and protect the sovereignty, unity, and integrity of India, very important. Sovereignty, unity, and integrity of India should be upheld and protected. To defend the country and render national service when called upon to do so. So, it is our duty to defend our country. And when the country needs us, definitely we need to offer our service. To promote harmony and spirit of common brotherhood amongst all the people of India, transcending religious, linguistic, regional, and sectional diversities, to renounce practices derogatory to the dignity of women. So, we may be having a lot of diversities, but overcoming all those diversities like religious, linguistic, regional, and sectional diversities, we need to have that spirit of common brotherhood. That fraternity should be there. And also, they need to renounce any kind of practices that are derogatory to the dignity of women. To value and preserve the rich heritage and our composite culture. The rich heritage and composite culture of our country should be valued. To protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for living creatures. Very important. So we need to protect the environment, we need to protect the forest, we need to protect the ecosystem that we are living in. Then to develop the scientific temper, humanism, and the spirit of inquiry and reform. So promoting science, promoting the logical thinking, promoting the rational thinking, so scientific temper, humanism, and the spirit of inquiry and reform. Then to safeguard public property and to abjure violence. Safeguarding public property and abjuring violence, to strive towards excellence in all spheres of individual and collective activity so that the nation constantly rises to higher levels of endeavor and achievement. So you have to strive towards excellence, whether it is individual or collective activity. Whether when you are actually growing, you can see that your country is also growing. So like that, everybody should excel in whatever they are actually doing. To provide opportunities for education to his children or what between the age of 6 and 14 years. So this is a fundamental duty of every parent. Then the duty was added by the 86th Constitutional Amendment Act of 2002. Okay, these are the major fundamental duties of the Indian Constitution, enshrined in the Indian Constitution. So what are the significance of the fundamental duties? These duties remind us Indian citizens of their duty towards the society, fellow citizens, and the nation. Okay, we will be reminded about it. It warns citizens against anti-national and anti-social activities. It inspires citizens and promotes sense of discipline and commitment among them. And it also helps the courts in examining and determining the constitutional validity of the law. Okay, so very, very important to understand about the fundamental duties. Please go through it and then understand it. What are the important fundamental duties enshrined in the Indian Constitution? So the next important topic is the president and governor. Okay, president and governor. So let's try to understand about president and governor. So basically, when you are looking at it, it is actually union government should come after the fundamental duties. But here I wanted to give you that similarity between the post president and governor, so that we can actually randomly choose president from union executive and the governor from state executive, so that you will understand its importance in an easy manner. Okay, so president and governor, let's understand that. So president is actually mentioned in part 5 of the Indian Constitution, part 5 of the Indian Constitution, and part 6 of the Indian Constitution mentions about governor. So one is state executive, another one is the central, the union executive. The union executive consists of president, vice president, prime minister, council of ministers, attorney general, etc. And state executive consists of governor, chief minister, council of ministers, advocate general, etc. Okay, then the president is the head of the Indian state, and the governor is the chief executive head of the state. Okay, so we are talking about the union as India, and we are also talking about a particular state. Then the president is the first citizen of India. Okay, and president is considered to be a nominal head. And Article 52 to 78 of the Union Executive talks about president. 52 to 78. Okay, so why president is called as the nominal head? Because the real head of the union, you can actually say that it is the prime minister. Okay, the real the de facto power lies with the prime minister and council of ministers. The de jure power is actually with the president. Same like that, here the governor is an agent of the central government and nominal head, and Article 153 to Article 167 of the Indian Constitution talks about governor, and the 7th Constitutional Amendment Act, which talks about the governor for 2 or more states. 7th Constitutional Amendment Act. Okay, 1956. Now, how the election is actually happening for the president and the governor, election and appointment. So regarding the president, Article 54 of the Indian Constitution talks about it, and regarding governor, Article 155 of the Constitution talks about it. And the president is actually elected by an electoral college, and this electoral college consists of the elected members of both houses of the parliament. So what are the both houses? Rajya Sabha and Lok Sabha. Then elected members of the state legislative assemblies of the state. So only the state legislative assemblies, not the state legislative council. Okay. Then elected members of the legislative assemblies of union territories of Delhi and Puducherry, legislative assemblies of the union territories. Only 2 union territories, Delhi and Puducherry. Then the nominated members and the legislative council members are excluded. A very important thing. Here, all the elected members will be part of the electoral college. Okay, from Rajya Sabha and Lok Sabha, and also from the state legislative assembly, not the state legislative council. Now, coming to governor, governor is appointed by the president. It is not an election process. It is appointed by the president, and the Constituent Assembly opted for the system. And the Supreme Court in 1979 says that office of the governor is not an employment under the central government. It is not an employment under the central government. It is an independent constitutional office. It's an independent constitutional office. When you're looking at the powers and functions of the president and governor, no, almost similar. Almost similar, you will be able to see. The nature is almost similar, but the more power lies with the president only, because the president is the one who is appointing the governor. The governor is not under the control and subordinate to the central government. So that is also we need to understand. Okay, so it is regarding the election and appointment of the president and governor. Now coming to the qualification. So the president, it's actually mentioned in Article 58, and regarding governor, it is mentioned in Article 157. And president, he should be an Indian citizen, very important. It is for both, for governor and for the president, he should be an Indian citizen. And his age should be minimum of 35 years, same for the governor also. Then he should qualify the conditions to be elected as a member of the Lok Sabha. So whatever conditions, eligibility conditions to be a part of the Lok Sabha member, that should be, qualified by this person. Then he should not hold any office of profit under the central government, state government, or any public authority. So, but sitting vice president, governor, minister of union or states are qualified to be a part of the presidential election. Okay, so this you need to understand. I'm not going into the details because you know these concepts. Now, when it is coming to the governor, we already mentioned that the governor should be an Indian citizen and should have attained the age of 35. And apart from that, certain conventions we are actually following. It is not a written in nature, but it's a certain conventions that we follow, that he should be an outsider. He should not be a member of that particular state. He should be an outsider. And president also to consult the CM of the state, the chief minister of the state concerned before appointing the governor. Okay, so this is regarding the eligibility conditions or qualification of the president and the governor. So these articles, please keep that in mind. Article 58 and Article 157. The conditions of office. Let's see the conditions of office. You can just read it and you can understand that. For president, he cannot be a member of Lok Sabha and Rajya Sabha. If he has been a member of either house, then he should vacate the seat on the first day of the as the president in the office, and he should not hold any office of profit. For his residence, Rashtrapati Bhavan is provided to him without payment of rent. Parliament decides his emoluments, allowances, and privileges. Rashtrapati Bhavan related to president. Then the same applies to the governor also. He cannot be a member of Lok Sabha, Rajya Sabha. If he has been a member of either of the houses, he should vacate the seat on the first day as the governor in the office, and he should not hold any office of profit. And for his residence, it is Raj Bhavan will be provided to him without the payment of rent, and the parliament decides his emoluments, allowances, and the privileges. Okay, so when you're talking about the articles, Article 15 and Article 158 of the Indian Constitution deals with president and governor. Then the parliament cannot diminish his emoluments and allowances during his term of office, and he is given immunity from any criminal proceedings, even in respect of his personal acts. And arrest or imprisonment of the president cannot take place. Only civil proceedings can be initiated for his personal acts, and that too after giving 2 months of prior notice. So this is the one we were also mentioning while we are discussing about Article 14 of the Indian Constitution, which mentions that everybody is equal before the eyes of law. But there are certain immunities which are enjoyed by the president and governor. We mentioned in that particular time itself. No, so this is it. Now, the parliament cannot diminish his emoluments and allowances during his term of office, and he is given an immunity from any criminal proceedings, even in respect of his personal acts. Same like that. Same like the president, the governor is also enjoying certain immunity. When a governor is responsible for 2 or more states, the emoluments and allowances payable to him are shared by the states in such proportion as the president may determine. So, if one person as the governor of 2 or more states, then the emoluments and allowances should be shared by these states. Then oath and affirmation of the president and the governor. Article 60 and Article 159 of the Indian Constitution deals with that. To faithfully execute the office, to preserve and protect and defend the constitution and the law, then to devote himself to the service of the well-being of the people of India. And it is administered by CJI, that is Chief Justice of India, or the senior judge in his absence. Same is applying to the governor also. So faithfully execute the office, preserve, protect, and defend the constitution and the law, devote himself to the service and the well-being of the people of the state. Okay, people of the state, and administered by Chief Justice of the High Court or senior judge in his absence. Okay. Term of office, President, it is actually coming under Article 56 and Governor Article 156. He holds office for 5 years. He can resign by addressing the resignation letter to Vice President. So very important, the President is the topmost position. No? So when President wants to resign, then that resignation letter will be addressing the Vice President. Then he can be removed by the process of the impeachment, and he can remain in the office till the successor assumes charge, and he can also be re-elected, and there is no cap on his re-election. Now coming to governor, governor holds office under the pleasure of the president only, because the president is the one who is appointing the governor, and the president can remove the governor. Governor may also get transferred. Governor shall hold office for a term of 5 years from the date on which he enters upon his office, and he can also resign by addressing the resignation letter to the president. Okay, so governor is actually addressing the resignation letter to the president. Then coming to the impeachment of the president, Article 61 of the Indian Constitution deals with that, and how the impeachment is actually processed or proceeded. It is on the ground of violation of the Constitution, but it is not clearly defined in the Constitution, and initiated by either House of the Parliament, Rajya Sabha or Lok Sabha, and charges to be signed by 1/4 members of the House, and 14 days notice to be given to the President. 2/3 members should pass the resolution and send to the other House for investigation. Then President has the right to appear and to be represented at such investigation, and 2/3 members of the House should pass. The President is removed upon the passage of the resolution by 2 houses. Okay, very important. And nominated members of the either House of the Parliament can participate in the impeachment process. The elected members of state legislative assemblies of Delhi and Puducherry cannot participate in the process. Very, very important. So, in the election process, the nominated members were not allowed to participate. But in the impeachment process, the nominated members of either House of the Parliament can participate. Okay, that's a difference you need to. The executive powers of the president and the governor. Very important to understand this one. Executive powers. For every executive action that the Indian government takes is to be taken in the name of the president. Every executive action taken by the Indian government will be taken in the name of the government. In the case of the state, it will be taken in the name of the governor. And he can make rules specifying the manner in which the orders and other instruments made and executed in his name and shall be authenticated. Same applies to the governor also. He can make rules for more convenient transaction of business of the union government and for allocation of the said business among the ministers. Okay, so union government aspects, the transaction of business in that area, he can make rules. In the same applies to the governor also, but it's regarding the state government. Okay, not the union government, it is regarding the state government. The prime minister and other ministers of the union are appointed by the president. Okay, union are appointed by the president, and chief minister and other ministers of the states are appointed by the governor. Okay, very important to understand that it is the union. Then the president also appoints the major positions. Okay, certain important positions: Comptroller and Auditor General of India, Chief Election Commissioner and other election commissioners, Chairman and members of the Union Public Service Commission, State Governors, Finance Commission of India, Chairman and members. He also seeks administrative information from the Union government. And regarding the governor, governor appoints the State Election Commissioner, the Chairman and members of the State Public Service Commission, Vice Chancellors of universities in the state, and he also seeks information from the state government regarding administrative. He appoints the Attorney General of India and determines his remuneration. He also appoints the National Commission of Scheduled Caste, Scheduled Tribes, other backward classes. He appoints the Interstate Council. He appoints the administrators of the Union territories. And regarding governor, he appoints the Advocate General of the state and determines their remuneration. And it is the responsibility to appoint the tribal welfare ministers in the states of Chhattisgarh, Jharkhand, Madhya Pradesh, and Odisha by the governor. It's the governor's responsibility. Now, he encourages Prime Minister to submit for consideration of the Council of Ministers any matter on which the decision has been taken by the minister but which has not been considered by the council. Okay, so it is the responsibility of the president to ask that to the Prime Minister. Same applies to the governor in terms of the chief minister. He can actually ask the chief minister, and he can declare any area as scheduled area and has the power with respect to the administration of scheduled areas and tribal areas. The president has that power. Any areas can be declared as a scheduled area and has the power to administer there. And a constitutional emergency in the state is recommended to the president by the governor. Okay, regarding the governor, no, the governor actually recommends the constitutional emergency in the state. The governor also enjoys extensive executive powers as an agent of the president during the president's rule in the state. Okay, during the presidential rule, then the governor enjoys unlimited power. Okay. Now, legislative powers of the president and the governor. So, the president summons and prorogues the parliament and dissolves the Lok Sabha. So, in the case of the governor summons and prorogues the state legislatures and dissolves the state legislative assembly. And the president addresses the Indian Parliament at the commencement of the first session and after every general election. And the governor addresses the state legislatures at the commencement of first session and after every general election. And the president appoints the speaker, deputy speaker of the Lok Sabha, chairman, deputy chairman of the Rajya Sabha when the seats fall vacant. And here the governor appoints speaker, deputy speaker of state legislative assembly and the chairman, deputy chairman of the state legislative council when the seats fall vacant. Then the president nominates 12 members to the Rajya Sabha from literature, science, art, and social service, those who are experienced in that area. And he consults the Election Commission of India on questions of disqualification of MPs, the president. And here the governor appoints 1/6 of the total members of the Legislative Council from the fields of literature, science, art, cooperative movement, and social service. And he consults the Election Commission of India on questions of disqualification of MLAs. With respect to the bill introduced in the parliament, the president can give his assent, withhold his assent, and return the bill. Okay, what do you mean by return the bill? If the bill is again passed by the parliament with or without amendments, the president has to give the assent. So return the bill to the parliament, and if it is actually coming back without any changes or with any changes, then he has to sign. Then in the case of the governor also the same, the governor can give his assent, withhold his assent, return the bill, and one more activity or action that the governor can take is reserve the bill for president's consideration. So in instances where the bill introduced in the state legislature endangers the position of the state high court, then definitely that bill can be reserved to the presidential consideration. And regarding the president summons a joint sitting of Lok Sabha and Rajya Sabha in the case of a deadlock. Joint sitting. So both houses members will be sitting in one particular session. That is the joint sitting. President promulgates the ordinances. Governor also promulgates ordinance in the state, and the president lays the following report before the parliament: the reports of the Comptroller and Auditor General, Union Public Service Commission, Finance Commission, etc. So here the same thing applies to the governor also. The Comptroller and Auditor General's report, a State Public Service Commission report, and the State Finance Commission report, etc., will be submitted before the state by the state legislature by the governor. Financial powers. The prior recommendation is needed for the introduction of money bill, president's prior recommendation. And in the case of the state legislative assembly, the governor's prior recommendation is needed for introduction of money bill. And the president causes to be laid before the parliament the union budget. Union budget will be laid before the parliament by the president, and the governor causes to be laid before the state legislature the union budget. And his recommendation is a prerequisite to make the demand for grants. Same applies to the governor also. And make advances out of contingency fund of India. Same applies to the governor also. And the president constitutes the finance commission every 5 years. Distribution of revenue center and the state will be done by that. Okay. So same applies to the governor also in the state. Okay. Judicial powers. So president appoints the Chief Justice of India and other judges of the Supreme Court and High Court. And he can seek advice from the Supreme Court, but not binding. Okay, whatever the advices he is actually getting, it is not binding. Then he has the pardoning power also under Article 72 of the Indian Constitution. He has been conferred with the power to grant pardon against punishment for an offence, against union law, punishment by a martial court, or death sentence. Okay, President has these exclusive powers with relation to the pardoning one. Then regarding governor, The president consults the governor while appointing the judges of the High Court. Governor will be consulted. In consultation with the state high court, governor makes appointments, postings, and the promotions of the district judges. And in consultation with the state high court, the state public service commission, he also appoints the persons to judicial service. Okay, so it is applying to the governor's judicial powers. Now, what is this pardoning power? So he has here the president and the governor has following pardoning powers: pardon, reprieve, respite, remit, and commute. Okay, both governor and the president has these powers. And now what is this pardon? Pardon means completely absolves the offender from all sentences and punishment and disqualifications and places him in the same position if he had never committed the offense. That is pardon. Completely absolves the offender. Now commutation means exchange of one thing for another. In simple words, to replace the punishment with less severe punishment. For example, for rigorous imprisonment, we will be giving simple imprisonment. Reprieve means temporary suspension of death sentence. For example, pending a proceeding for pardon or commutation. Okay, temporary suspension. Respite means awarding a lesser punishment on some special grounds. For example, pregnancy of women offender. So lesser punishment will be provided. Then remission means the reduction of the amount of sentence without changing its character. For example, sentence of 1 year may be remitted to 6 months. That is remission. So all these powers are enjoyed by the president and the governor. The ordinance making power of the president. Article 123 of the Indian Constitution deals with the ordinance making power. And when the ordinance is in use, okay, what is the advantage of an ordinance? When both houses are not in session, then if there is an urgency comes and there is a need for making a particular law, during that time the president or the governor can actually promulgate ordinance. President of India can promulgate ordinance during the recess of the Parliament of India. The recess of the Parliament refers to when both houses of the Parliament or any of the two or houses of Parliament is not in session. Okay, the ordinance making powers of the president are not discretionary in nature. The president can promulgate ordinances only on the advice of the Union Council of Ministers. So basically, when the Parliament is not in session or either one house is not in session, because without the approval of both the houses, we cannot actually pass a particular law. So even if one house is present also doesn't matter. So that time the only option is ordinance, and that ordinance can be promulgated by the president only, but with the prior recommendation or advice of the Union Council of Ministers. Now, an ordinance making power of the presidents are coextensive with the legislative powers of the Parliament. Okay, now let us understand that. The ordinance issued by the president has the same force and effect as well as limitations of an act of the Parliament. Exactly the same like an act, it actually enjoys the powers. The ordinance making powers of the president are absolute. The president needs no instruction to promulgate ordinances. President can withdraw an ordinance at any time. Very important. All ordinances issued by the president cease to operate unless laid before and ratified by both houses of the Parliament within 6 weeks of the reassembly of the Parliament. Because in our Indian system, the lawmaking should be done by the Parliament. Okay. So if it is not, ratified by the Parliament, then it will cease to exist. Then the ordinance may cease to operate even earlier than the prescribed 6 weeks if a resolution disapproving it is passed by the Parliament. So if there is a resolution is passed by the Parliament to disapproving it, okay, disapproving a particular ordinance, then before that 6 week itself, it will actually cease to operate. Now coming to the vice president. Okay, after the president, we need to understand about the vice president. So the vice president, the main articles which are actually connected with the vice president are as follows. Article 63 of the Indian Constitution talks about the Vice President of India. 64 talks about Vice President to be the ex officio chairman of the Council of States, which is Rajya Sabha. The Vice President to act as President or to discharge his functions during the casual vacancies in the office or during the absence of the President. Then election of the Vice President is actually done or dealt in Article 66. Article 67 talks about term of office of the Vice President. Article 68 talks about the time of holding election to fill vacancy in the office of Vice President and the term of office of person elected to fill casual vacancy. Article 69 talks about oath or affirmation by the Vice President. Article 70 talks about discharge of President's functions in other contingencies. And Article 71 talks about matters relating to or connected with the election of the president or vice president. Okay, so these are the important articles which are actually connected with the vice president. Vice president is considered to be the second highest office in the country, second highest office, and accorded a rank next to president in the official warrant of presidents. After the president, the official warrant of presidents, it is the vice president. Article 63 of the Indian Constitution mentions the post of the vice president. The post of vice president of India is modeled on the lines of American vice president, almost the same lines of the American vice president. The electoral college consists of elected and nominated members of both the house of the parliament. Okay, elects the vice president. So in the election of the president, we were only mentioning about the elected members of the parliament, but here elected and nominated members of the parliament. The states have no role in the election process. Okay, the proportional representation by means of single transferable vote, and the voting is by secret ballot. That is the system that we are actually following. And Supreme Court decides all disputes and doubts in connection with the election. So Supreme Court is the one has the final say in matters related to disputes and doubts. Vice president cannot be challenged on the ground that the electoral college was incomplete, like the existence of any vacancy among the members of the electoral college. So that doesn't matter. If the election of a person as vice president is declared void by the Supreme Court, acts done by him before the date of such declaration of Supreme Court are not invalidated. They continue to operate or remain in force. Okay, very important to understand this. Now, what's the eligibility? He should be an Indian citizen. He should have attained the age of minimum 35 years. He should qualify the conditions to be elected as a member of Rajya Sabha. He should not hold any office of profit under the central government, state government, or any public authority. But the sitting president, vice president, governor, minister, or of union and state are actually qualified to compete in the election process. Oath or affirmation of the vice president: to bear true faith and allegiance to the Constitution of India, to faithfully discharge the duties of his office and administered by president or some person appointed in that behalf by him. Okay, so basically that's the oath of the or affirmation of the vice president, administered with the oath is administered by the president or the person who is appointed by the president. The conditions: he cannot be a member of Lok Sabha and Rajya Sabha. If he has been a member of either of the house, he should vacate the seat on his first day as the vice president in the office, and he should not hold any office of profit. Vacancy: when he completes the term of 5 years, when he resigns, or when he is removed. Vacancy occurs. On his death, when his election is declared void. So in all these circumstances, vacancy occurs. Vice president holds the position for 5 years, and he can resign before 5 years by handing over the resignation to the president. Very important. He can be removed from the office by a resolution passed by the majority of all the then members of the Rajya Sabha. Okay, effective majority agreed to by the Lok Sabha simple majority. So why Rajya Sabha is having a more say in this one? Because the vice president is the ex officio chairman of the Rajya Sabha. Then resolution can be initiated in the Rajya Sabha only. That is why Rajya Sabha is getting more prominence here. 14 days advance notice can be given, and no ground for removal is mentioned in the Constitution. So in the Constitution, there is no exact reason for the removal of the vice president. The vice president acts as the ex officio chairman of the Rajya Sabha. In this capacity, his powers and functions are similar to those of the speaker of the Lok Sabha. Okay, so whatever functions enjoyed by the speaker of the Lok Sabha, the same is actually applied to the chairman of the Rajya Sabha, that is the vice president. In this respect, he resembles the American vice president, who also acts as the chairman of the Senate, the upper house of the American legislature. He acts as the president when a vacancy occurs in the office of the president due to his resignation, removal, death, or otherwise. And he can act as a president only for a maximum period of 6 months, within which a new president has to be elected. Okay, maximum 6 months that person can, actually function as the president, but within 6 months, election has to be conducted. Further, when the sitting president is unable to discharge his functions due to absence, illness, or any other cause, the vice president discharges his functions until the president resumes his office. So that is the main duty of the vice president, being the ex officio chairman of the Rajya Sabha, and also when during the absence of the president, he functions as the president. While acting as the president or discharging the functions of the president, vice president does not perform the duties of office of the chairman of Rajya Sabha. During this period, those duties are performed by the deputy chairman of the Rajya Sabha. Very important, because two duties he won't be able to perform. So during that time, when the vice president is acting as the president of this country, during that time the activities of the Rajya Sabha will be dealt by or led by the deputy chairman of Rajya Sabha. The vice president draws salary in capacity as the ex-officio chairman of the Rajya Sabha. So not as a vice president, but as the ex-officio chairman of the Rajya Sabha. In 2008, Parliament increased the salary from 1.25 lakh to 4 lakh per month, and vice president is entitled to daily allowance, free furnished residence, medical, travel, and other facilities. Very important to understand this. So these are some of the important aspects related to the DPSP, fundamental duties, president, governor, and vice presidents. Very important topics in the civil service examination. You can expect questions from these topics, because in the previous exams of previous years, you could see that there were many references or many questions which are actually connected with these topics. So please make sure that you go through these concepts in a very detailed manner. What I'm doing here is to give you an idea about a swift revision of the entire things, but it is your responsibility to recollect all those information and go through it again and again and again. Okay, so that you can actually recollect information really well in the examination hall. So all the very best, and stay tuned for the next part of Indian polity, and the rest of the portions will be covered in the next part of the Indian polity sessions. So thank you so much for watching the video.